Well, it is a Friday and I am in the office. I was not in court today, but I was in the office talking to clients, doing some interviews and some follow-up consultations with some existing clients. So it's been a very, very busy day in our office. And, people often think that you hire a lawyer just to be your courtroom advocate. And I just put out a blog article regarding why that simply isn't the case. It's a very recent case. It happened, I believe, this week or last week, involving a nonprofit director in Philadelphia who chose to enter a juvenile courtroom. He is not a lawyer, and he took it upon himself to address the court and the judge. And again, thinking that, I believe, that he was helping in some way. But it turned out that the judge obviously did not want him there. He was not permitted to be in the courtroom because it was a closed session. And being a non-lawyer, he was not familiar with the courtroom procedure or how to address a court or understand why and what could happen if he refused to comply with the court orders. And he was arrested. And now he faces, in addition to obstructing justice, a resisting arrest charge, because again, he didn't understand how to deal with police. And the case brings up an important point. It doesn't matter what type of education you have. I'm sure this individual is educated, but he's not a lawyer. And he didn't do anything but muddy up the waters for the juvenile for whom he was probably appearing for and trying to, I guess, in his opinion, advocate for. Well, that's not your job. Your job may be the advocate outside the courtroom, but once you step above that bar into that courtroom circle or that rectangular area, that is for lawyers, judges, members of the bar, and that's why we call it the bar. So knowing that this individual should not have done what he did, and now, unfortunately, he's going to have 2 misdemeanor charges that they have to deal with. Now, do I think he will be sentenced to jail? I don't. I think that ultimately his case is going to resolve in some type of non-trial disposition or probably get some kind of diversion. But it doesn't have to go that way. And quite frankly, he may have trouble getting that diversion program, given his alleged history with dealing with the justice system. He's been very critical of judges and district attorneys, and I think he may have some trouble there. And again, it's something that could have been avoided had he just listened to probably the advice of an attorney. I'm sure likely he was given advice, maybe even from the juvenile's attorney for whom he was attempting to interject himself into a place where he didn't belong. He was probably given that advice because I've given that advice to members of the public, friends, family, as to why I don't want them addressing the court. And if they are going to address the court, they're going to do it through me, through a direct examination, and I'm going to be permitted to control it. I'm never going to have someone go up there and address the court without me understanding, have a full understanding of what they're going to say. And that just goes for both verbal and nonverbal communication to the court. How to look, how to stand, how to look around the courtroom when it's not your turn to talk, how to respond to perhaps a tough question, how to respond from perhaps a very harsh judge. And these are very important points. I've done a blog article previously on the power of nonverbal communication in court. And I say this not to be this pompous and arrogant lawyer. I say it because you really don't know what you don't know. And you are walking into a situation where you really can do some damage, not only to yourself, but to the individual who you are attempting allegedly to help. If you have questions about how to act in a courtroom or what you should or should not be doing when you are represented, give us a call, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week, website gambleandlaw.com. As always, a tremendous resource for you and your family. All of my books, my blogs, my videos are available there in one convenient format. In addition, we have our podcast. Hope to have more podcasts out this week. We also have our videos. At this point, I have over 500 instructional videos on every area that we cover at Gamble and Law. But once again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. Also, today is Friday. We have the weekly e-update, which went out to over 4,000 of our current and former clients in Pennsylvania and New Jersey. Some fantastic articles. It being Friday, I always give my weekend advice. If you are stopped for suspicion of DUI in Pennsylvania or DWI in New Jersey, do not refuse the chemical test. It will never have a criminal case. Never consent to a search of your home or your property. If police are asking for consent to search, they probably don't have probable cause to search. And remember, warrantless searches are permissible in New Jersey. In Pennsylvania, police usually need a search warrant to search your car. That being said, do not give consent. But once again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey. Have a great weekend, and I'll talk to you all very soon.